2012 Concateno, Tricotech, and Trimega are parties to another controversial case in the family courts. This judgment considers a subsidiary issue that has arisen in care proceedings. Suffice it to say that a major issue in the proceedings was the mother's drug taking and its impact on her capacity to care for the children. She therefore underwent hair strand testing carried out in June 2011 by the second intervener, Trimega Laboratories Limited, Trimega. The results purported to show that the mother had been using increasing amounts of cocaine and opiates right up to the date of the sample being taken. The mother, however, vehemently denied that this was the case, and she was therefore given permission to obtain a second analysis on a sample taken at the same time. The results of the second test, carried out by Concateno Cardiff Limited, also known as Tricotech but hereafter referred to as Concateno, appeared to confirm the mother's version that she had not used drugs as described or at all for approximately the previous 4 months. Faced with this stark conflict of expert evidence, the proceedings were transferred to the High Court. The evidence appeared to raise questions as to the utilization of hair strand testing to detect drug use. Accordingly, both Concateno and Trimega were given permission to intervene in the proceedings. The specific issues listed before the President were as follows. Which of the drugs tests on the mother's hair sample provides accurate and reliable evidence? A. Trimega only. B. Concateno only. C. Both Trimega and Concateno, or D. Neither? What general guidance, if any, should be given to family courts about the use and interpretation of, and reliance upon, hair testing in the light of the apparent inconsistencies in the testing results provided by the two companies? Does hair testing remain a reliable method for determining drug use in family courts? It was suggested by the parties to the care proceedings, and accepted by the court, that the explanation may involve a systemic problem with hair strand drug testing. In the event, it was conceded by Trimega shortly prior to the start of the hearing that its analysis was erroneous and unreliable. The precise error was, and remains, unclear. Trimega said, although this is not accepted by Concateno, that it was believed that there had been an error in the process by which the hair sample was collected. The first issue was therefore resolved by an agreement placed before the President on the first morning of the hearing and recited as follows in the eventual order made at the conclusion of that hearing. And upon it being agreed between the first and second interveners that 1. The second intervener accepts that a human error, believed by the second intervener to be in the collection process, has occurred in the production of its hair strand test results in this particular case. 2. The answer to issue 1 therefore is B. 3. The second intervener will produce a report, to be filed and served in these proceedings by no later than the 1st of March 2012, setting out A. As definitively as they can, the nature and source of that human error, and B. The steps that they have taken to avoid the risk of such human error recurring in other cases. The interveners were not required to attend the IRH before me on the 15th of March, but by that date a report had been filed on behalf of Trimega in accordance with the agreement recited in the President's order of the 14th of November. In addition, a skeleton argument from Mr. Robin Tolson QC on behalf of Concateno was filed shortly before the hearing, addressing what were described as the inadequacies of the Trimega report, making further criticisms of Trimega's work on this case, and suggesting general guidance that might be given by the court. And that Trimega should file a position statement in response to the latest skeleton from Concateno. Mr. Tolson's submissions can be summarized from his various documents as follows. First, he contends that Trimega's inadequacies risk belittling and damaging the reputation of this important testing and the companies carrying it out. Trimega risk throwing out the industry's healthy baby with the bathwater that is Trimega's own. He describes the report filed on behalf of Trimega to explain the error that occurred in this case as, inter alia, a whitewash, and inadequate, and submits that it not only highlights glaringly flawed processes at Trimega but also exposes all previous allegedly independent expert reports filed on Trimega's behalf as themselves deeply flawed and filed in plain breach of the duties imposed upon independent experts with family proceedings, as set out in Family Procedure Rules 2010 Practice. Direction 25A. He says that the error has never been subject to scrutiny, that it should as a matter of law be tested and that the system will have failed if it cannot be tested. Mr. Presti, for Trimega, submits this overriding objective would not be served by extending the inquiry in the manner proposed by Concateno. Through counsel, Trimega accepts that it did not fully or accurately investigate the reason for the difference between its test results and those of the first intervener when first called upon to do so, and that, initially it focused disproportionately on the aspects of the evidence that it felt supported its position and undermined that of the first intervener, and that it was not as swift as it should have been to appreciate the contrary evidence and the wider picture. Mr. Presti further informs the court that Trimega has, following wide-ranging review of its service, instituted a large number of changes geared to improve the service that it provides and to ensure that errors of the kind that occurred in this case are not replicated in others. Later in his skeleton argument he gives detail of the changes that Trimega has introduced to its collection and other processes. He therefore argues that a finding as to the actual source of Trimega's error is not necessary to resolve any threshold, assessment or welfare issue concerning the subject children. Secondly, Mr. Presti points out that any guidance that the court may give affects not just the interveners but every other drugs company offering or looking to offer a hair-strand drugs testing service to family courts. As a matter of essential fairness, they would have to be given the opportunity to comment on any guidance contemplated and or to formulate and suggest guidance of their own. Thirdly, Mr. Presti refutes Mr. Tolson's criticism of the report filed by Trimega, and submits that the primary motivation of Concateno is to obtain a judgment critical of Trimega, and guidance from the court, that could be used for commercial advantage. For all the rather pious talk of standing up for the industry, the evidence of a company acting to further its own self-interest is pretty plain to see. There are further references to commercial factors later in the skeleton argument. For example, through counsel Trimega acknowledges that it should have apologized to the court and to the mother for failing to deliver an accurate and reliable service in this case. Mr. Presti adds, however, that, but for the presence of its major commercial rival at court, ready to extract the greatest commercial advantage out of any such apology, it would have done. This is a care case. It is not some public inquiry. I am equally unpersuaded that it would be appropriate or proportionate to allow any further share of the court's limited resources to continue the inquiry into the nature of Trimega's error. Mr. Tolson describes the report prepared following the hearing before the President as a whitewash and accuses Trimega of falsely asserting that the error lay in the collection process to conceal more fundamental flaws in their systems. He sets out the justification for that assertion in considerable detail. Mr. Presti denies this allegation and goes into even more extensive detail as to the investigation carried out by Trimega into the cause of the human error in this case. In order to investigate those matters, fully and fairly, the court would in my judgment have to conduct a hearing lasting several days, summoning several witnesses from Trimega for oral evidence, and in all probability commissioning further independent expert evidence. At the conclusion of such a hearing, the court might give a judgment setting out its findings, but no order would follow. I do not regard this court in these proceedings as the appropriate forum for the investigation of these matters. In my judgment, a hearing for the purposes of giving guidance, or investigating the nature of Trimega's error in this case, would be disproportionate and an inappropriate use of the court's resources, given the enormous demands on the time of judges of the family division. It was the court that, for reasons explained above, raised the question whether guidance should be given. The court has now concluded that no such guidance is needed beyond the agreed points set above. It was the court that directed Trimega to investigate and report on its error. Having read that report, the court has concluded that any further inquiry by this court would be disproportionate and inappropriate.